I received the question, which sort of sounds like a sentence frag. They wanted to know about the smooth transition of assets. But the smooth transition of assets from when to when? From an individual name into a trust, or from a trust into a beneficiary, from a will into a beneficiary? So the question didn't really have much context. So let me attack one of them. So if a person prepares and formulates a trust, and now you have a trust, the trust is a vehicle, it's a document, it's a thing that exists that is an empty shell. So we now have a trust, and if you have individual assets in your name and you want them protected with all of the bells and whistles and fanfare of a trust, the asset has to go from the individual name into the trust. And that is pretty smooth, pretty easy transition. So if you have a house or a property in your individual name, you have to retitle that house or property from your name to the trust. If you had joint assets, two people have to sign into the trust. And then there might be an issue. Is it an individual trust? Are you going to only take some of your assets, or a portion of a property, or is it a joint asset going into a joint trust? Like say in the example of a husband and wife. If you have a bank account, brokerage account, there are forms you can fill out taking the asset from your individual name to the name of the trust. Easy peasy, lemon squeezy.